For nearly a century, Americans have lived under a system where their right to carry a firearm depended not just on the Constitution, but on government permission slips, endless red tape, and a patchwork of state laws that could turn law-abiding citizens into criminals overnight. But now, in a stunning development, the Supreme Court has issued an emergency decision that shakes the very foundation of permit systems nationwide. And the Department of Justice, yes, the DOJ, has stepped in to support it. This is not just another case, not another debate in Congress, not another headline that fades in 24 hours. This is a seismic shift that could mark the end of firearm permits in America as we know them. Think about what that means. No more expensive fees just to exercise your rights. No more local officials deciding who is worthy of protection. No more patchwork of rules that criminalize you for crossing a state line. For the first time, the federal government is signaling that the Second Amendment means what it says. The right to keep and bear arms shall not be infringed. And here's the kicker. This isn't speculation. This is already happening. The DOJ just announced it will no longer prosecute law-abiding citizens in D.C. for carrying registered rifles and shotguns, a move that directly acknowledges recent Supreme Court precedent. So tonight, we're diving deep. By the end of this breakdown, you'll understand what the Supreme Court just did and why it matters. Why the DOJ siding with this decision is a once-in-a-generation moment. How this could ripple into every state permit system in the nation. And most importantly, what this means for you, your family, and your rights moving forward. If you want to stay ahead of the headlines and never get blindsided by the laws that affect you most, make sure you subscribe right now, because tonight's story is one that history will remember. Let's get into it. Chapter 1. The Shockwave, Supreme Court's Emergency Decision. When people hear the words Supreme Court decision, they usually think of slow-moving cases argued for months, sometimes years, before a ruling comes down. But every now and then, the court acts fast, issuing what's called an emergency decision. That's what just happened, and the ripple effects are being felt in every corner of the country. At the heart of this emergency order is the question of permits. For decades, states like New York, California, and the District of Columbia insisted that you needed government approval before you could carry a firearm. They created complex permit systems, often may issue, meaning bureaucrats had discretion to deny you even if you met every requirement. The court has already started dismantling this structure with cases like Bruen in 2022, where it ruled that may issue systems violated the Second Amendment. But the emergency decision that just came down goes a step further. It suggests that all permit systems, even shall issue systems, may be on borrowed time. Why? Because the court said plainly, the right to bear arms cannot depend on prior government approval. That doesn't just affect one city or one state. That's a principle that applies nationwide. And here's where things get explosive. The Department of Justice, which has historically defended restrictions, has now stepped in to back this reasoning. That means the executive branch of the U.S. government is signaling a shift, siding with a position that could effectively end firearm permits across America. For decades, pro-gun groups dreamed of this moment. Few thought it would come through the DOJ. Chapter 2. Why firearm permits exist in the first place. To understand why this decision is such a big deal, we have to go back to the beginning. Why do firearm permits exist at all? The uncomfortable truth is that many permit laws were born out of racism and fear. After the Civil War, Southern states passed black codes designed to prevent freed slaves from owning firearms. They knew they couldn't outright ban gun ownership. The Second Amendment was too clear, so they created licensing schemes that allowed local sheriffs to decide who could or couldn't carry. Predictably, the result was widespread discrimination. Fast forward to the 20th century. Big cities facing rising crime adopted similar systems. New York's Sullivan Act in 1911 required permits to carry handguns, giving police broad authority to deny applications. The law's defenders claimed it was about public safety, but in practice, it targeted immigrants and working-class citizens. By the 1960s and 70s, permit systems had spread across the country. Some states made them easy, shall issue. Others made them nearly impossible, may issue. But the effect was the same. The government decided when, where, and how you could exercise a constitutional right. That's the background against which today's emergency decision lands. When the Supreme Court says permits themselves may violate the Second Amendment, it isn't just rewriting recent law. It's unraveling over a century of legal precedent built on shaky, discriminatory foundations. And the DOJ siding with that position means those old arguments about public safety, about discretion, about good cause, are collapsing under the weight of the Constitution. Chapter 3, The Road to Now, Heller, McDonald, and Bruen. To see why the court is moving this way, you have to understand the roadmap. In 2008, the court decided District of Columbia versus Heller. For the first time, it ruled that the Second Amendment protects an individual right to own a firearm, not just a collective right for militias. That case struck down DC's handgun ban and became the cornerstone of modern 2A law. 2 years later, in 2010, McDonald versus City of Chicago applied the Second Amendment to the states through the 14th Amendment. That meant cities and states could no longer hide behind local control to justify sweeping bans. Then came the bombshell, New York State Rifle and Pistol Association, FIFIR, Bruen, 2022. The court ruled that May issue permit systems were unconstitutional. More importantly, it established a new standard. Gun laws must be consistent with the history and tradition of the Second Amendment at the time of the founding. That standard is what fuels today's emergency decision. There's simply no historical precedent for requiring ordinary citizens to ask permission before exercising their right to bear arms. If you had the right in 1791, you still have it today. Bruen was the earthquake. Today's emergency ruling is the aftershock, the kind that topples buildings weakened by the first quake. And with the DOJ now backing this logic, even the most entrenched permit systems are at risk of collapse. Chapter 4, the DOJ's role, why this is different. For decades, the Department of Justice has been the enforcer of gun laws. Whether it was defending the NFA, backing assault weapon bans, or supporting restrictive carry regimes, the DOJ has almost always been on the side of more control, not less. That's why their support for this emergency decision is so shocking. It's not just that they're declining to prosecute in DC, it's that they're openly aligning with a Supreme Court standard that undermines permit laws across the country. Why the shift? Some believe the DOJ recognizes the writing on the wall. If they fight this battle and lose, the court could issue an even broader ruling that wipes out permit laws overnight. By supporting the decision now, they may hope to control the pace of change, softening the political blow. Others think this is part of a larger strategy. By siding with the court, the DOJ may be preparing to focus its resources elsewhere, on areas like red flag laws, background checks, or new forms of regulation that aren't directly tied to permits. Whatever the reason, the effect is the same. The DOJ's support makes it harder for states to resist. If even the federal government admits permit laws are unconstitutional, how long can states like California or New Jersey hold out? Chapter 5, Impact on DC. Felony charges dropped. Nowhere is this shift more visible than in the District of Columbia. For decades, DC was one of the most restrictive jurisdictions in the nation. Carrying a rifle or shotgun outside your home, even if registered, could result in felony charges. But last week, U.S. Attorney Jeanine Pirro announced a stunning change. Her office will no longer prosecute law-abiding citizens for carrying registered rifles and shotguns in the district. She called DC's law a direct violation of Supreme Court precedent and said it could no longer stand. Think about that. In the very city where Heller was decided, where some of the most restrictive laws in the country have stood for decades, the DOJ is now saying those laws can't be enforced. For citizens of DC, this is a sea change. No longer do you face felony charges for simply exercising your rights. And for the rest of the country, it's a signal. If it can happen in Washington, it can happen anywhere. This is the DOJ and the Supreme Court together telling America, The days of permit regimes are numbered. Chapter 6, State-Level Domino Effect. What happens in Washington never stays in Washington. The D.C. shift, where the DOJ has stopped prosecuting citizens for carrying registered rifles and shotguns, is just the beginning. Already, lawmakers in states like California, New York, and New Jersey are scrambling. These states have built entire political legacies around strict permit regimes. They've argued for decades that requiring citizens to ask for permission was common sense. But here's the problem. If the Supreme Court is signaling that all permits are unconstitutional, then those systems are living on borrowed time. And when the DOJ joins in, it strips states of their best legal shield. We've seen this pattern before. After Bruen struck down New York's May issue scheme in 2022, other states with similar laws collapsed like dominoes. Now the domino line stretches even further. Not just may issue versus shall issue, but the entire question of permits at all. Imagine the effect if state after state is forced to recognize permitless carry as the national standard. Millions of Americans who were once shut out of their rights would suddenly be empowered, and states that try to resist could find themselves buried in lawsuits they can't win. Chapter 7, The Gun Rights Response. Gun rights organizations are moving fast. Gun Owners of America, the Second Amendment Foundation, Firearms Policy Coalition, and the NRA, often divided by strategy, are all seizing on this moment. They see the DOJ's support as a golden opportunity to press harder in court. If the federal government is admitting permits can't survive constitutional scrutiny, then lawyers can take that quote and hammer it into every courtroom across America. Already new lawsuits are being drafted to challenge state-level permit systems. Advocacy groups are fundraising aggressively, telling supporters, this is the fight we've been waiting for. But it's not just about lawsuits. On the ground, activists are pushing for constitutional carry bills in legislatures. Over 27 states already recognize permitless carry. With the Supreme Court and DOJ leaning in this direction, that number could quickly jump, pushing America toward a de facto nationwide standard, even before the courts finish the job. For the gun rights community, this isn't just a win, it's validation, proof that decades of pressure, cases, and advocacy are finally breaking through. Chapter 8, The Gun Control Counterattack. Of course, not everyone is celebrating. The opposition is already mobilizing. Figures like Senator Chris Murphy and Senator Chuck Schumer have sounded the alarm, warning that a permitless America would lead to chaos. They're preparing countermeasures, everything from raising taxes on firearms to creating new categories of restricted weapons to pushing sensitive place carry bans that effectively gut the right in practice. We've already seen a preview with Murphy's attempt to hike the NFA tax to $479. That was no accident. It was a test case. If the courts strike down permits, expect lawmakers to respond with new fees, new licenses, and new hurdles that look different on paper but achieve the same goal. Gun control groups are also preparing legal challenges of their own. They'll argue that states have a compelling interest in permits, citing public safety and crime statistics. But here's the problem. Under Bruen's history and tradition standard, those modern arguments carry little weight, unless they can point to a founding-era precedent for permits, and they can't. Their legal footing is weak. The truth is, opponents are afraid not just of losing permits, they're afraid of losing the entire playbook they've used for decades to restrict rights. Chapter 9, Everyday Impact for Gun Owners. So what does this all mean for you, the everyday gun owner? First, it means the end of criminalizing simple mistakes. No more felony charges just for crossing a state line without the right paperwork. No more jail time because a sheriff decided you didn't have good cause. No more confusion about whether your permit is valid in one county but not the next. It also means greater freedom to exercise your rights consistently across the country. If permit systems fall, constitutional carry becomes the default. That doesn't mean chaos. It means a level playing field where responsible citizens don't need permission slips to protect themselves, but there will be growing pains. Expect conflict at the local level, especially in states hostile to gun rights. Police departments may resist change, some courts may drag their feet, and until this is fully settled, gray areas will remain. That's why staying informed is critical. Knowing your rights, understanding the law in your state, and keeping track of court rulings will be the difference between safety and risk. The bottom line, the system is changing fast, and the old days of permits, restrictions, and arbitrary denials may soon be gone for good. Chapter 10. What comes next? This isn't the end of the fight, it's the beginning of a new phase. In the months ahead, expect more lawsuits, both from gun rights groups pressing the advantage and from gun control groups fighting back. Political battles, state legislatures will either embrace permitless carry or try to double down on restrictions. Election fallout. With 2026 elections on the horizon, this issue will be front and center, a defining test of where candidates stand on the Second Amendment. Supreme Court review. Ultimately, many of these cases will climb back to the court, and if today's emergency decision is a preview, the justices may soon deliver a final, sweeping ruling that ends permit regimes once and for all. The DOJ's support is the wild card. Will they keep siding with the Constitution, or will political pressure push them back into old habits? Either way, this story is far from over. Here's the bottom line. The Supreme Court just cracked open the door. The DOJ just pushed it wider. And now, for the first time in American history, the permit systems that have restricted gun rights for over a century may be on the verge of collapse. This isn't just a court case. It's a constitutional turning point, one that could redefine what it means to bear arms in America. So let me ask you, do you believe this is the first step toward true nationwide constitutional carry? Or will states fight back harder than ever to keep permits alive? Drop your thoughts in the comments, because this debate isn't just happening in courts and legislatures. It's happening right here with you. If you believe in staying informed, staying prepared, and staying free, then hit subscribe to Firearms Law Advisor right now and turn on notifications. Because in the weeks ahead, we'll cover every twist and turn of this fight. And you'll want to know the truth before it hits the headlines. Share this video with someone who needs to hear it. Talk about it with your friends, your family, your community, because the only way to protect your rights is to understand them. Stay sharp, stay informed, and above all, stay free.